let's go ahead and begin your Week 13 lecture. This week we're going to talk about the law in the courts. Specifically, we're going to deal with just federal courts since this is your federal government class. So any questions about municipal law or Texas state law or anything like that, we won't really address today. We're going to just handle federal courts, particularly the Supreme Court, the Court of Appeals, and then the district courts. So let's go ahead and first, we're going to start off with the first part of this slide here, the law. We need to first talk about the different types of law. There's different types of questions that each court handles, and law is typically broken down into two different categories. There's civil law, and then there's criminal law. So let's go ahead and tackle the first one of those, which is civil law, rather. Civil law is a particular substantive category of law. It typically handles things such as divorce, contract law, intellectual disputes. Things that don't necessarily involve an exact crime, but do involve a breach of contract or a breach of intellectual copyright or things like that. So it's disputes among individuals, groups, corporations, and the government. Like I said, it handles things such as divorce, contract law, intellectual disputes, and so forth. Punishment usually requires monetary or punitive payments, whereas criminal law usually involves serving jail time or paying a fine. This is usually paying some sort of damage to another party, compensatory or actual damages. Out-of-pocket expenses for harm done to you, including nominal damages, so expenses for harm done to you, medical bills, etc., things like that. Punitive damages, on the other hand, punitive damages tend to handle a lot more societal things. Society and courts will not tolerate unlawful behavior. The damages are awarded to punish the defendant rather than compensate the plaintiff. So the biggest example of a civil law breach, or the biggest thing that you may have heard of that may handle civil law, maybe besides a divorce or maybe a contract breach or something like that, an example of a punitive damage or something like that would be the 2013 lawsuit settlement with the NFL. The NFL has had a number of civil lawsuits against them, particularly pertaining to concussions and the effects that concussions can have on NFL players after they retire. The studies show that concussions may lead to mental disorders later on in life, including a number of cases we can point to that have led to suicide. So the NFL was held responsible for the well-being of its players, particularly since the players play for the benefit or the profit of the NFL. And in 2013, the NFL had to handle another lawsuit in which they admitted liability for concussion-related deaths and injuries. This lawsuit is probably the best example of a civil lawsuit that I can bring forth to you, particularly since it was such a high-profile case. There was $765 million that the NFL had to pay to compensate players and their families for those concussion-related injuries and deaths. It was considered a deal for the NFL because $765 million really wasn't that much for a billion-dollar industry such as the NFL. But you had 18,000 potential class action members and 4,500 former players that signed on to the lawsuit that received some sort of payment for the damages that actually occurred, including emotional damages as well as physical damages. So that'd be the example of a civil lawsuit. Civil lawsuits, just for the purpose of your test, just know that they tend to deal with contract law, divorce, punitive damages, compensatory damages, actual damages, and things like that. So that's probably the best example I could give you of a civil lawsuit as well. So moving on to criminal law, ones that we're much more familiar with and that we usually hear about a lot more. Criminal law deals with actual criminal behavior. It defines crimes and provides punishment by charging someone with violating a statute, a law. In other words, federal and state government is usually the prosecutor, particularly when you're convicted of a crime. Because you're convicted of a crime or charged by an officer, which is a branch of the state or an actor for the state, therefore the federal or state government is always the prosecutor. It will always be the criminal versus the state of Texas, or the criminal versus the United States. Punishment usually involves fines and imprisonment. You have this guilt and innocent phase first, though. Here in the United States, we have the typical saying that you're innocent until proven guilty, although increasingly you could point to a number of cases where people feel that they're guilty before they're even proven guilty. But you have the guilt and innocent phase where it's up in the air. And then as soon as you have the trial, and then you have the sentencing phase. So after a guilty verdict, let's say you or the criminal, I'm sorry, I keep saying you, but let's say the criminal was found guilty, and after the guilty verdict, the state procedures then govern the sentencing. So whichever state you committed the crime in, that's how you are then sentenced based on the state law that you are charged in. The court will obviously examine aggravating and mitigating factors, things that may have led you to do that crime or things that may have proven your innocence in that crime. And then you'll also look at a number of other factors, such as if you're a repeat offender, someone was injured during the crime, your own background, your own character as well, your nature of the crime, merit consideration, or you express remorse or regret. Those are all factors that will be taken into the sentencing phase of the crime. So those are very important things to keep in mind if you ever are convicted of a crime. I hope you're not. But if you are, just know that the courts do look at these things, particularly when they pertain to criminal law. So for the different types of law that we've talked about, we have civil law and then we have criminal law. Those are the only two that you need to know for the test. I just hope that you know the difference between those two for your test, and you should be good to go there. But if you have questions about maybe what the difference between civil and criminal law, or if you want some more specifics about civil versus criminal law, feel free to send those questions my way. But now we're going to go ahead and move on to the structure of the court. So we talked about law. Let's go ahead and the rest of the day we're going to talk about the courts themselves. And we're going to first deal with the structure of the courts. Because we're dealing with federal courts, not a lot of people are familiar with the actual structure of federal courts. We hear a lot about courts, particularly municipal courts, local courts, state courts, and things like that. But federal courts are not as well known, it seems like, among the general population at large. So, with the structure of the courts, it looks something like this. This is the structure of the federal courts here in the United States. And we're all familiar with the very top one here, the Supreme Court. But because we're going to be talking about the federal courts themselves, we're actually going to deal with a number of these other columns here. We're going to talk about the Circuit Court of Appeals. We're going to talk about the Court of Appeals for the Federal Circuit. And then we also may mention, the U.S. Court of Appeals for the Armed Forces, international trade courts, and things like that. But if you were in my Texas government class, you may remember that we talked about these 50 state Supreme Courts. We talked about the Texas Supreme Court in my Texas government class. But for the purposes of today, we're mainly going to talk about the left side of this chart here because we're dealing with federal courts. The structure of the federal courts breaks down into three main tiers usually. You have what are called the constitutional courts because they were set up by the Constitution in Article 3. You have the Supreme Court, which we're all familiar with, and then directly under the Supreme Court, you have the Court of Appeals, in which the Supreme Court gets a lot of its cases. If the courts of appeals can't reach a verdict, or that the defendant or the plaintiff appeals it, then it will go to the Supreme Court. But under the courts of appeals, they get most of their cases from the district courts, which are spread out throughout the United States and are broken down by geographical regions and broken down within states as well. Texas actually has, I believe, 5 district courts, 5 federal district courts within its own state. And then the Court of Appeals, you'll see on a map later, involves Texas, Louisiana, and Mississippi. And then the Supreme Court is the overarching court for the entire United States. Breaks down a little something like this as well. If that last slide didn't do it for you, this is basically the same slide here. You have the Supreme Court above the Court of Appeals and then above the 94 district courts. The Supreme Court and all federal courts were created in Article 3, Section 1. Article 3 of the Constitution, remember, deals with the judiciary. Remember, Article 1 dealt with the legislature, Article 2 dealt with the executive, and Article 3 deals with the constitutional courts. It states that the judicial power of the U.S. shall be invested in one Supreme Court and such inferior courts, those courts of appeals and those district courts, and such inferior courts as the Congress may ordain and establish. That's a very interesting clause because Congress actually does have the power to establish more courts if they want to. So far the system is working well with our 13 courts of appeals and our 94 district courts, but let's say they need a population shift occurred or something like that. Congress could actually establish more courts if they want to. So know for the purpose of your test that courts are set up in Article 3, Section 1 of the Constitution. Let's go ahead and talk a little bit more about the Supreme Court itself. The Supreme Court consists of 9 judges, or justices, if you will. 9 judges, and this number is established by Congress. Congress can actually expand the number of judges in the Supreme Court if they wanted to. This actually happened in the 1930s with FDR, Franklin Delano Roosevelt. He wanted to actually make it 12 Supreme Court justices because he wanted more judges that were of his political party or of his political ideology. He wanted to get more legislation passed, and he wanted it to be ruled constitutional by the Supreme Court. He wanted more legislation passed to handle the national emergency of the Great Depression. Because he wanted to handle the national emergency of the Great Depression, he thought that if he could get more judges on his political ideology or his political party that agreed with him, he could then pass more legislation to help economic recovery, and it wouldn't be ruled unconstitutional by the current 9 Supreme Court justices that he had that typically disagreed with him or disagreed with his legislation. So just a little side note there about FDR. I think it's very interesting because he tried to pack the court to favor his political party or his political views, and he wasn't allowed to because Congress wouldn't expand the number of judges. So we've had 9 judges for quite a while. We have 1 Chief Justice, and then you have 8 Associate Justices. Right now, currently, the Chief Justice is John Roberts, so know that for your test. Please know who the current Chief Justice of the Supreme Court is, and it is John Roberts. Judges are, if there is a vacancy in the Supreme Court, the judges are appointed by the President, or they're nominated by the President, and then they're confirmed by the Senate. The Senate only has to approve the judge by a majority vote. A simple majority will either reject or approve of the president's appointment or nomination. So we haven't had a vacancy in the Supreme Court, I believe, since 2009 or 2010 when Judge Sotomayor was elected or was approved into the Supreme Court, and I believe that's the newest addition to the Supreme Court. They're chosen. The Supreme Court justices are usually chosen because of their legal or judicial experience. They have to have a very rich background or very knowledgeable background into the law and the proceedings of the United States courts. They typically have Ivy League law degrees, so they're typically well educated. 8 of the 9 justices currently usually serve on a Circuit Court of Appeals for a while. They typically have served on one of the 12 Circuit Court of Appeals so that they are familiar with the general law that is going on within the United States. And a number of other factors are included into the presidential consideration for nomination as well, such as judicial perspective, temperament, and ideology as well. So you want someone that generally agrees with your views on the law, and the president will usually nominate someone of their own political ideology or political background. So you typically have the judges that are elected to the Supreme Court generally reflect the president in which they were elected. So judges that were nominated by Bill Clinton typically agree with or typically have Bill Clinton's views on politics. Same way with George W. Bush, such as Samuel Alito, someone like that. They typically have the traditional political views of George W. Bush as well, and same thing with Barack Obama and so on. So it'll be interesting in 2016 who gets elected president, because it could have a huge impact on the Supreme Court itself and who is nominated to the Supreme Court. If you have a Democrat elected in 2016, you'll probably see you'll have a vacancy in the Supreme Court most likely during their tenure, so you'll have someone that is nominated that has a similar view to that Democrat that may be elected in 2016, and then vice versa, the exact same thing with the Republicans. So that's just a little bit about the Supreme Court and the own justices. Who are the current justices? Well, it breaks down into basically 3 different little columns here. You have the conservatives over here on the left, you have the moderates here on the right, and then you have the liberals over here on the right. You have the moderates here in the middle, I guess I should say, sorry. And then you have the liberals over here on the right. So conservatives, moderates, liberals going left to right. The conservatives, you currently have 4 of them that typically identify with the conservative ideology. You have Roberts, Alito, Thomas, and Scalia. So if you want to remember that really easy, it's RATs. RATs are the conservative judges. The moderates are Kansas, KS. Kennedy, Sotomayor are the 2 moderates typically considered to be moderates anyways on the Supreme Court. And then on the liberals, you need to remember KGB. KGB is really easy to memorize. because it is the communist. It was the USSR's own secret service, basically, or CIA. And so if you associate liberals with leftists and communists, then KGB may be easy to memorize. For the liberals, Kagan, Ginsburg, and Breyer are typically considered the most liberal on the court. So Rats, Kansas, KGB. That's how you remember the current justices. Roberts, Alito, Thomas, Scalia, Kennedy, Sotomayor, Kagan, Ginsburg, Breyer. I have a little star here for Justice Roberts, because remember, Roberts is the Chief Justice, so he gets the little star right there. So if you want to pause a moment, memorize these current justices. I will ask you a question on the test, something like which one of these is not a current Supreme Court justice. So if you have a general idea, if you remember Rats, Kansas, KGB, you should be able to very easily memorize who the current justices are. And run through those real quick. So take a moment to pause these, memorize these for your test, and remember which one of these is not a Supreme Court justice, or not. Remember which one for your test to be able to identify which one of them is not a current justice. All right. Moving on about the Supreme Court here. Supreme Court is very unique because it has original jurisdiction as well as appellate jurisdiction. So what is original jurisdiction? Original jurisdiction means that they are the first one to hear the case. They are the first ones to hear the arguments and decide on it. And it's very rare that the Supreme Court has original jurisdiction. There's a few unique requirements or prerequisites for them to be the one to have original jurisdiction. But it does happen. Original jurisdiction means it goes directly to the Supreme Court, or it goes directly to the court that is named. Supreme Court does have original jurisdiction in cases involving foreign diplomats. So say there was a case of the United States versus another foreign diplomat, or that a foreign diplomat committed a crime while in the United States. The Supreme Court would be the very first one to get to hear that case. Original jurisdiction also exists in cases involving a state, let's say Texas versus, we'll just use Texas since we're here in Texas. Texas versus the United States. So let's say that Texas had a legal dispute with the United States, say over maybe a border dispute, or say maybe a river dispute, an interstate river, interstate commerce, or something like that. Texas versus the United States, that would go directly to the Supreme Court. Let's say Texas had a dispute with Oklahoma. Texas and another state, if that kind of dispute exists, that goes directly to the Supreme Court. And Texas and Oklahoma actually have had a number of cases actually go directly to the Supreme Court, particularly dealing with river resources as well as nuclear waste, because nuclear waste doesn't just stop at the border. It's a national issue. So Texas versus Oklahoma actually does happen quite a bit. Texas has disputes with its neighbors. And so if Texas has a dispute with another state, that goes directly to the Supreme Court. Cases involving Texas and a citizen of another state, let's say a citizen from Louisiana committed a crime or had a contract dispute with someone in Texas, then Texas versus the citizen of another state would go directly to the Supreme Court. And then finally, any case dealing with a foreign nation goes directly to the Supreme Court as well, which makes sense. So, Supreme Court does have original jurisdiction in those kind of cases. The question on your test will be something, once again, like which one of these does the Supreme Court not have original, in which of these situations does the Supreme Court not have original jurisdiction? That'll probably be the question on your test. The most one that we're familiar with, though, is the appellate jurisdiction. We're used to the Supreme Court having appellate jurisdiction. And that means that it hears the case on appeals. It means that it couldn't be decided in another court, or that the plaintiff or the defendant wanted to appeal the case because they felt the decision wasn't correct. That's when the Supreme Court has appellate jurisdiction. It's heard on appeals from another court. And there are two different ways this can go through. There's the federal route. That means that it goes through the U.S. Courts of Appeals, it goes through the Court of Appeals for the Federal Circuit, and it could also go through the legislative courts as well. It means that this case was not decided, or that the plaintiff or defendant had a legitimate concern that they wanted to appeal. If it goes through these three courts and that situation arises, then it goes up to the Supreme Court. Supreme Court can also have appellate jurisdiction through the state route. Let's say that the highest state court of appeal couldn't decide the case, or that the defendant and plaintiff had a concern, or if there is also a significant federal question involved. Let's say that this case could actually have a major impact on, say, your Fourth Amendment rights or your First Amendment rights, maybe your Second Amendment rights. If there is a significant federal question involved that needs to be handled that is not just exclusive to Texas or a particular state, but could rather have an impact on all states or have an entire impact on how all public sector things are handled or something like that, then it can go on appeals from a lower state court directly to the Supreme Court and be heard on appeals by the Supreme Court. So that's what appellate jurisdiction basically is, meaning here's the case on appeals, meaning it didn't hear the case first, rather it moved from some court up to the Supreme Court. I hope that makes sense. So if there's any questions between what the difference between original jurisdiction is and what appellate jurisdiction is, please be sure to ask. Please send me an email and I can try to clarify that. But please know how the Supreme Court has original jurisdiction and then when the Supreme Court has appellate jurisdiction. Please know the difference for the purpose of your test and be sure to know when those cases occur. Alright, so enough about the Supreme Court. What about courts under the Supreme Court? Well, there's lots of them, to be quite honest. The one under the second tier that we talked about there, under the Supreme Court, is the Courts of Appeals. The Courts of Appeals consist of 11 appeals courts allocated to the 50 states. So there's 11 appeals courts, and then those 11 appeals courts are divided up among the 50 states. So there's more states than there are appeals courts, so you'll have more than one state per appeals court. And here in Texas, we share our federal courts of appeals with ourselves, obviously, and then Louisiana and Mississippi. You're going to see this on a map here in just a little bit. There's these 11 appeals courts, and then there's one court for the District of Columbia. The District of Columbia is so important that it actually gets its own federal court. And then there's a special court called the Court of Appeals for the Federal Circuit. So that you have 13 total courts of appeals. You have 11 plus 1 plus 1, 13. The special court, which is the Court of Appeals for the Federal Circuit, here's cases in very specialized types of cases, such as patents, copyrights, claims against the U.S., and then international trade. So the Court of Appeals for the Federal Circuit mainly deals with, once again, civil law, going back to the very beginning of this lecture. They tend to deal with only civil law, so patents, copyrights, intellectual sorts of things, claims against the U.S., contract laws, and then international trade, which tends to also be contract law. So those are your courts of appeals. They're the ones that are directly under the Supreme Court. Each judicial circuit is also very unique. Judges are appointed for life by the president and, once again, confirmed by the Senate because they're a federal judge. The number of judges for each courts of appeals ranges from 6 to 28, depending on how big or how many states the courts of appeals handle. Cases are not heard by all 6 to 28 judges, though. Cases are generally heard in panels of 3. 3 because that way you'll have a majority. You'll have 2 out of 3 in most cases. You may have a unanimous vote as well. You may have 3 out of 3. But cases that are generally heard in panels of 3 because it's easy to hear, you can divide up the work, you can handle more cases that way, and it just is much more efficient. The court, though, maybe let's say it's a high-profile case, may hear the cases en banc, which means they hear it in total. All of them are there for the total case or for the whole case. And that would have to be a pretty special case. It'd have to be deemed important enough for all of them to hear it. It is unique because the Courts of Appeals has appellate jurisdiction only. They don't actually have direct jurisdiction or original jurisdiction on any case. The Courts of Appeals is the Courts of Appeals because they only hear appeals, which makes sense. They may hear cases from U.S. federal district courts, regulatory commissions, and then legislative courts of district status. So, not that you really need to know that for your test, but just know that that's where they get their appellate jurisdiction, and that they have appellate jurisdiction only. That'll probably be a question on your test. The Courts of Appeals also has what is called the writ of certiorari, which means that they get to, if there's a case that's in a lower court, they can issue an order. to actually have that case brought up to them directly. So a writ of certiorari is an order by a higher appeals court to a lower court to hand up the case for review. So that's another way that the Court of Appeals has appellate jurisdiction, is that they can directly see a case, bring it up to them, and then hear that case on appeals. So that's basically the Court of Appeals. Just to rehash the writ of certiorari, I just wanted to give you a basic definition of it. It's an order by a higher appeals court to a lower court to hand up the case for review. So the Court of Appeals can do that, and also the Supreme Court can do that as well. Let's say the Supreme Court looks at a lower court and says, wow, that case down there in that court is actually a really important case. It may have a very important federal question involved. Let's go ahead and bring that up to our level, to the Supreme Court, and then we can hear that case directly and answer the question. All right. So what about the district courts? So the nation is actually divided by Congress into 91 judicial courts. So this is where you have more states than district courts. So you'll actually have several states that have more district courts, or have several district courts within their state borders, I guess I should say. No district is larger than one state, so you may have states such as South Dakota, North Dakota, maybe even Rhode Island, that are really small states. They may only have one district court per state, and that district court only handles cases within the entire state of South Dakota, North Dakota, Rhode Island, all those smaller states. Some states have several districts, though. Texas and California have 4. Each district has between 2 and 28 judges, depending on what the population and how many cases they're handling as well. Judges, once again, because they're federal judges, are appointed by the Senate, or appointed by the President and confirmed by the Senate. There is this thing called senatorial courtesy. We're not really going to go into that. It's just that, let's say that the district court resides within that particular state, then a senator from that state gets senatorial courtesy to nominate a judge for that district court. These judges serve life terms as well. So if you're a federal judge, you have it pretty well made. You have life terms, and you get a pretty nice salary to boot, and your position is not vacant until you decide to resign. So, or die, I guess, as well. I guess that is a particular option as well. So those are the district courts. District courts have original jurisdiction only. Remember the courts of appeals? They have appellate jurisdiction only. District courts are unique because they have original jurisdiction only. They never hear any cases on appeals. They hear cases for federal crimes, civil suits under federal law, diversity of citizenship cases, bankruptcy proceedings, admiralty and maritime jurisdiction as well, so anything that happens out on the ocean. And then they also get to review some of the federal agencies and then bring them up on charges or kind of shame them just a little bit as well. So district courts handle a number of cases, particularly questions dealing with federal law and things like that, which makes sense because they're a federal court. So that's the types of cases that the district courts get to hear. They never get to hear it on appeals. So here's a little map for you. This is how the courts are broken down. We have the numbers 1 through 11 here for the federal courts, or for the federal courts of appeals and their circuits. And then you can see these little lines going through Texas here and California here. Let's see it for another one. There's New York. It has some lines within it. Those are the district courts. So you can see here in Texas we have the North District Court, we have the West, the South, and the East, which makes sense. That's typically how Texas is divided into geographical regions. When you talk about North Texas, West Texas, East Texas, South Texas, that's typically how it's broken down anyways. And so you can see that the district courts divide some of the states, or that there's districts within particular states. And remember, in Texas we have 4. I know I said 5 earlier in the lecture. Just know for the purpose of your test, though, that Texas actually has 4 district courts, and I'll go ahead and put that question on your test. So just wanted to give you a little map, give you a little idea where the district courts are. Like I said, no district is bigger than one state. So like I said, you have the South Dakotas, North Dakotas, Nebraskas, and even my home state of Kansas. We only have 1 district court for our entire state. Even though we belong, I guess Kansas belongs to the 10th district, which includes these. And then remember, Texas belongs to the 5th district, which includes Texas, Louisiana, and Mississippi. And that's the 5th Courts of Appeals, or the Fifth Circuit for the Courts of Appeals here in Texas. So, all right. Hopefully I didn't confuse you too much. Once again, if you have any questions on these court stuff, I can try to clarify that if you send me a question. I'll be sure to handle that. So, all right. Judicial selection. For district courts, district judges are appointed by the President, confirmed by the Senate. I believe I already said that. And then the role of senatorial courtesy. I kind of wanted to go ahead and clarify that. Once again, it's just the tradition that a senator of the President's party from the state in which the district resides recommends judges for that particular court. So I believe I already covered that. I'm not sure why I added an extra slide on, so let's go ahead and move on. All right, court decisions. Court decisions, sorry. I'll go ahead and delete those slides when I upload them to the course website itself, because I already talked about judicial selection in pretty much detail, already. All right, so let's go ahead and talk about court decisions. Sorry, I'm kind of skipping around here. I got a little off track there. So anyways, court decisions. Which cases are heard? Well, the truth is that the docket is actually really discretionary. That means that the Supreme Court can decide which cases they hear, which cases they don't want to hear. The Supreme Court controls the number of cases that it reviews. Usually, the Supreme Court only handles 80 to 100 cases per year. So that's not a whole lot, particularly when you consider that there are usually 10,000 cases that are presented before the court for review. The Supreme Court itself only gets to, or only decides to hear about 80 to 100 of those 10,000 cases that are presented to them each year. What decides whether that case is heard? Well, first off, it must be a real case, and there must be a controversy behind it, not a hypothetical question, an actual controversy that could have a significant federal question involved. One of those kind of prerequisites that could happen is that there could be a conflicting decision in the lower courts. Let's say the district court decided something and then the Court of Appeals decided something else. Then the Supreme Court would maybe want to look at that to try to hash out the differences between the two courts. The Supreme Court really likes it when there's important questions of civil rights or civil liberties involved. Let's say maybe there's something belonging to the Fourth Amendment that is in question, or maybe the Second or the First Amendment, such as your freedom of speech, your right to privacy, your right to gun ownership, to bear arms, I guess you should say. If there's important questions of civil liberties or civil rights, then the Supreme Court will definitely want to look at that case as well. And then the Supreme Court may have an interest in correcting a wrong lower court decision. Let's say the majority of the Supreme Court disagrees with how the lower court decided, then the Supreme Court itself will decide to hear that case and correct the wrong decision of the lower court. Most cases reach the court through writ of certiorari, which once again is that the Supreme Court wants to bring up that case for review from a lower court. There's also this thing called Q theory. There's a number of Qs that the justices look at. It says that the justices look at cases and decide which cases to hear based on key factors that may be present in the case. So Q theory really relates back to those important questions of civil rights or civil liberties, interest in correcting wrong decisions in lower courts, as well as conflicting decisions in lower courts. Those are the Qs that the judges will most likely look at. So you can kind of predict, if you wanted to go ahead and look at all the 10,000 cases that were up for review, you can usually predict which out of those 10,000 are going to get selected based on those Qs that the judges look at. So that's basically what Q theory is just looking at important questions that the Supreme Court itself looks at and then picking those cases because the Supreme Court is going to pick those cases. So, all right. The number of cases, though, that the Supreme Court has been presented with has increased exponentially over the last 60 years or 60 or 70 years. And so this little graph kind of shows you just the cases that are filed in the U.S. Supreme Court, and that the U.S. Supreme Court has to shuffle through and pick out which ones they're actually going to hear. And like I said, it's around 10,000, and this is kind of where it was left off in 2005. I would imagine in 2010 and then here in 2015, I would assume that number is even maybe a little bit larger, maybe 12,000 or 13,000. But for the purpose of the lecture and the purpose of what the statistics have for us in terms of today, you can see that it's increased pretty exponentially up to around 10,000. In 1940, they only had about 1,000 cases to shuffle through. And I think a lot of this has to do with the increase in technology and communication and the way that you can communicate through email and things like that faster than ever before is what I'm trying to say, basically. You can communicate a lot faster than ever before, so these cases are heard or presented to the court in more volume or in mass numbers more than ever before. So I just wanted to kind of show you how it's increased from the 1940s, where only 1,000 cases were presented before the United States U.S. Supreme Court, to today, where we have around 10,000 cases presented to the U.S. Supreme Court. So, all right. The Solicitor General. Let's go ahead and talk about this just a little bit. This is actually a really, really important position within the United States politics. And even though we don't hear a lot about him, or them, I guess I should say, we don't hear a lot about them, we don't hear a lot about what they do or anything like that, they're actually very important in deciding what cases are heard before the Supreme Court, as well as arguing for cases before the Supreme Court as well. The Solicitor General is simply just the attorney who argues all cases before the court where the U.S. is a party. So the Solicitor General is basically an attorney for the United States. In many ways, he's considered the 10th justice because he brings so many cases before the Supreme Court. About 70% of the cases requested by the Solicitor General to be heard by the Supreme Court are heard by the Supreme Court. So 70% of the cases that are presented by the Solicitor General actually go on to be heard by the Supreme Court. And that's why the Solicitor General is so important. In a lot of ways, the Solicitor General has a lot of control of what is actually on the docket before the Supreme Court. And then not only that, he is actually present in the courtroom while the Supreme Court is deciding these cases. He's arguing on behalf of the United States, or the United States as an interest group, I guess I should say, before the Supreme Court. In many ways, the Solicitor General screens out undeserving litigation and provides cases that deserve serious consideration. So that's why the Solicitor General is so important. The Solicitor General has a huge role in which cases are put before the U.S. Supreme Court to actually be heard, and then he's actually the attorney for the United States, so he's one that argues argues for the United States before the Supreme Court, and has kind of is vested in the outcome of that case. So I kind of feel like I got a little off track there, but if you have questions about what the Solicitor General is, please send those my way. But just know that the Solicitor General is actually very, very important in terms of the Supreme Court and the way it functions, what cases it hears, and then how it decides cases as well. The current Solicitor General is Donald Verrilli Jr. I have a link to his website there. You can read up just a little bit more about the Solicitor General if you want to, and what he does and what his duties are and things like that. So, all right. So that's the Solicitor General. Let's go ahead and talk about different types of Supreme Court decisions. We like to think that the Supreme Court decisions are either yes or no and things like that. The truth is that it's not. They're very detailed. They're not just yes or no answers, black and white answers. They're actually well opinionated and well reasoned and based in law. So there's different types of Supreme Court decisions. There's pure quorum, majority opinion, concurring opinion, and then dissenting opinion. And then also plurality, but that's also very rare. So pure quorum means that the court renders a decision without an opinion. And so that would actually be an example of when the Supreme Court says this is unconstitutional, this is constitutional, this is legal, this is illegal, but they don't actually offer an opinion. This is actually very rare as well. The court usually likes to provide reasoning for the reason why it decided something, and so that's where you get these opinions. You have the majority opinion. The majority opinion, if it is in the majority opinion decides the winners. So that means that you have a majority of Supreme Court justices that have ruled this particular way and decides the winner. It writes how the court reached its decision. So it shows how the court reached its decision based on legal facts, precedent, constitutional law, and things like that. So it writes a very informed opinion about the case. A concurring opinion means that it agrees with the winners, but on different grounds. So they may have looked at it through a different amendment or for a different reason, but however, it does agree with the winners. The dissenting opinion is usually the ones that side with the losers of the case, which makes sense. It's dissenting. It's not in the majority. However, they still like to write their opinion for the fact that Supreme Court cases could be overturned in the future. Moreover, there may be a different set of circumstances in the future in which the Supreme Court may need to decide the other way. So it still writes an opinion to guide future courts or to guide the court in case the precedent is ever overturned. Supreme Court justices can look to cases years ago and say, you know what, I don't believe the Supreme Court made the right decision way back then based on their set of circumstances. But today the circumstances have changed. Let's look at that old case. Let's look at the dissenting opinion of that old case and see why they disagree with it, and see maybe if what they disagreed with applies to the current case. So if the precedent is ever overturned, the dissenting opinion is actually very important. It's a very important kind of document for the Supreme Courts of the future to look back on and say, you know what, that dissenting opinion way back when may have actually been right and can apply to the set of circumstances that are presented before us today. So that's why a dissenting opinion is actually really, really important. And then there's a plurality opinion. So let's say you have a 4-3-2 vote. That 4 wins. Remember, plurality just means that it's more than the other. So let's say you had 4 votes for the winner, you had 3 votes for the loser, and maybe you had 2 justices that chose to abstain from the case. That would be the idea of a plurality. The fact that the 4 is more than the 4 for that particular view is more than the 3 or the 2 that are against that view. So that's a plurality. But the Supreme Court rarely has that. Usually all 9 justices usually rule for the winner or the loser in the case. They're either in the majority or the dissenting. So plurality is actually very, very rare. All right. Limits on court decisions. The court decisions are determined by a number of things. They look to the Constitution for guidance, the way the Constitution was written, maybe the wording of the Constitution. The Constitution is actually a very open document. It can be interpreted in a number of ways by different people. And so the Constitution is something that the Supreme Court particularly looks to because it's the thing that guides U.S. law the most. But they also look to it for the fact that maybe a particular clause or maybe a particular section is interpreted in a different way. They look to statutory law, that makes sense, established laws. They look to precedent. They look on prior cases quite a bit to see maybe the Supreme Court already ruled on this in a particular way. Maybe we should keep that precedent up or overturn that precedent as well. Politics, even though we like to think of judicial officers as beyond politics, politics actually does matter a lot. The politics of the time and the way that the political landscape looks, that affects the courts quite a bit. And then practicalities of enforcement. If a law seems unpractical to enforce, or it seems an overbreach by the government or anything like that, then the Supreme Court can also decide based on the practicality of enforcement of that particular law to decide in that particular case as well. Key points in court decisions. The judiciary is actually a very important policy-making body. What they say or how they rule actually gets to establish the law itself. It actually determines whether the law can be enforced, whether that law is going to continue for a number of years, and also whether that policy is good for the United States at large. So that's a very important thing for court decisions. The judiciary also has considerable discretion in decision making as well. So that obviously makes sense as well. Each Supreme Court justice has a number of ways that he or she can vote, and therefore they have discretion in the way that they decide. And then finally, the judiciary is a political as well as a legal institution. We tend to like to think that it's only a legal institution, but let's be honest that the Supreme Court justices actually do have political agendas themselves and will decide accordingly on each case according to their own political beliefs or political ideology or political agenda. So those are the 3 key points to kind of take away from the court decisions themselves. All right, so that's the end of the slideshow. I'm actually going to go ahead and post your discussion boards online on the course website. So if you're wondering why they're not in the slides, that's the main reason why, is because, I didn't actually include them in the slides. So I'm going to go ahead and post those online on the course website on the discussion forum, so be sure to look out for those and be sure to answer those as well. So if you have any questions about the judiciary or the Supreme Court itself or anything pertaining to courts and law itself, please send those questions my way. It's actually a very fascinating kind of segment of our federal government, and it has a lot of power and things like that. So it's very important to be aware of the issues and things like that and what the Supreme Court does in particular. So, all right, I'll go ahead and close out this lecture. Any questions, please send those my way. Other than that, I will see you next week. All right.